May it please the court. My name is Jennifer Holliday. I appear today on behalf of appellants and cross-respondents, Garrett Ziegler and ICU LLC, doing business as Marco Polo. This is an anti-SLAPP order. This is an appeal from an anti-SLAPP order. The cross-appeal is from the anti-SLAPP order, and as the papers make clear, it is on a narrow issue of whether the court erred in applying the second prong, in the analysis on the second prong. The trial court...
Yeah, I'm sorry. Just let me interrupt you for a moment before you begin. And let me tell you that the briefing in this matter, as you well know, was significant. We've gone over all of the briefs. We've discussed the briefs. We're very familiar with the facts of the case. We're very familiar with the case, as will come as no surprise to anybody. What I would like you to focus on are, there were 5 underlying claims that we have to look to see if there's minimal merit. And it'd be helpful for me if both parties would really focus on the civil harassment claim. That seems to be one where it may have gone one way at the trial court, and it arguably should go the other way now. So if you'll focus on the civil harassment, that would be very helpful.
Thank you. The trial court allowed the civil harassment claim to proceed, but the statutes make clear that the civil harassment cause of action must be brought in a particular way with a particular form. That injunctive relief is available, not damages. And of course, in the complaint, the plaintiff alleged $1 million in damages from a civil harassment claim. The plaintiff is also briefed, and cross-appellant has briefed the issue of, the case of Angie M. versus Superior Court. That case, they claim, held that the court could imply a private right of action where the legislature did not include one. But in that case, it was, first of all, completely distinguishable insofar as it was a sexual molestation of a child, and there was a separate claim for negligence, and that the fact that there was an underlying cause of action for battery, that the court could imply that and could use it for support for a negligence claim. It did not hold that the court could imply a private right of action where none existed. On the civil harassment, I would argue that there is an attempt to expand the civil harassment claim into a private right of action under civil harassment that exceeds the boundaries of what the legislature allows, which is to bring a particular type of claim with a particular form to a particular courtroom, in the Los Angeles Superior Court in this case, that alleges the types of harm that constitute harassment, and allows the court to consider whether or not injunctive relief is proper at that time. If the plaintiff had done so and established that there was enough of a cause of action or enough facts to allow the court to issue a temporary restraining order, then the trial court would have had some evidence that the procedure had been properly followed and that there was sufficient evidence to state a cause of action under the statute. By bypassing that, the plaintiff and cross-appellant effectively circumvented the statute and all of the procedures that the legislature has put in place, because that is obviously a very serious allegation. So in terms of the civil harassment, it doesn't state minimal merit because they simply didn't comply with the statute.
Okay, go ahead. You want to move on to some of the other issues you have?
Thank you. We clearly argue that the litigation privilege bars all of the civil torts. under 47B. We argue, obviously, that it is a statutory immunity, and that once we have met the first prong, which, of course, my colleagues concede that the first prong was met, under Towner versus County of Ventura in 2021, this court explained that prong 1 is the appropriate time to address whether or not the protected conduct is illegal, not prong 2. So once we've established that the conduct is protected by the statute, the plaintiff can respond by explaining how that conduct is illegal. That gets us into flatly. But here, the cross appellant has conceded that prong 1 is met. They did not raise the illegality argument under prong 1. They want to focus on prong 2. Prong 2, it's now too late to discuss illegality.
Under prong 2, are we primarily focused on minimal merit?
We are focused on minimal merit, but what it presumes is that prong 1, they have waived their argument as to illegality under Towner versus County of Ventura, because they haven't made that argument that the conduct, which is civil, we're here in civil court, there is no evidence of illegality. There's no, the defendants and the trial court made clear that the defendants and appellants did not concede illegality, did not admit illegality, as they did in Flatley, and that there was there's no police report, there's no evidence that there was illegal conduct, conclusive evidence. So when we move to prong 2 on minimal merit, and we look at these claims, we already know that they fall within the statute, meaning they're privileged in some respect under the statute. It's free speech, it's news gathering, it's publication. So then the prong 2 analysis becomes about the First Amendment or any other immunity that also might attach. In terms of minimal merit, each one of the causes of action are classic examples of attempts to circumvent the anti-SLAPP statute and try to chill free speech. I'd like to reserve my time for the rest, unless there are any questions.
All right, thank you.
Thank you.
Good afternoon, Your Honors. Brian Sullivan on behalf of Respondent and Cross Appellant Kevin Morris. I will address first the civil harassment 527.6 claim. In that, it is not a specific procedure only for a restraining order. It is a specific procedure to obtain an expedited restraining order if you follow the exact statutory procedures. It even says in the statute that it is not the exclusive remedies for this type of cause of action, which means you can bring it as a civil case if you aren't seeking immediate relief from a restraining order, i.e. imminent threat of someone trying to hurt you or harm you, but rather you're seeking damages for being harassed at another point in time. In regard to Angie R., that case specifically involved, a statute that was criminal, that did not provide a right of civil remedy. But the court said, no, it was geared towards protecting the plaintiff from the conduct that was made illegal. So you can bring an action under that. And there's other cases that cite that as well. Lasco v. Jules Myers, Michael R. versus Jeffrey B., Rybicki v. Carlson. Violation of a statutory duty or statute embodying a public policy may give rise to civil liability, even though no specific civil remedy is provided for in the statute itself. Many of the cases that were cited, contrary to that, were not penal code statutes. They were regulatory statutes for insurance industries, for example, where a plaintiff was saying, well, they didn't comply with this statute and I was harmed, but the statute's not directed to protect that person like a civil remedy, say, for precluding doxing and posting people's private information online so people could harass them. In regard to all the discussion about illegality of the first prong and applying into the second prong, that is all incorrect. The case law is the illegality precludes that any protection by the First Amendment, because the First Amendment protects speech but does not protect illegal actions. And I believe it was in the Novartis series of cases against a group of animal rights activists that were going after scientists that work for a pharmaceutical company, where they trespassed. They threw stuff at the scientists. They engaged in more than just speech, and their conduct was, while they were speaking while on the front yard of one of the scientists, they were breaking the law of trespassing. So they were not protected by anti-SLAPP. It was not considered an exercise of First Amendment. That was totally separate from the second prong of the anti-SLAPP analysis, which is minimal merit. Akin to a summary judgment motion, as the courts have recognized, has the plaintiff presented sufficient evidence to show minimal merit that they can proceed, that they can prove that the defendant is civilly liable for the conduct alleged. Just because you're exercising your First Amendment rights doesn't mean that you can't be held civilly liable, such as intentional infliction of emotional distress. It is an exercise of First Amendment rights to threaten someone, but you can still be held liable if your threats cross a line. Defamation.
So does this duplicate the causes of action because you have civil harassment and then in addition you have IIED to deal with?
Yes, I would say that civil harassment is broader than just IIED, but the grounds for civil harassment, one of them is the conduct that constitutes intentional infliction of emotional distress.
Okay. Civil harassment, my understanding is you really have to you have to use the forms that are provided by the Judicial Council. Is that correct, or am I correct?
That you don't. So in order to do the expedited procedure to obtain a restraining order and immediate and also a temporary restraining order, yes, you would have to use that procedure. But again, the statute also specifically says this procedure does not limit other remedies. That procedure exists for people to obtain quick resolutions when they feel that they're in danger, their life is at risk, but it doesn't preclude them suing for damages when harassed. And then to turn to the litigation privilege argument, that it just doesn't apply here. Only one of the statements that were in the complaint or in the record involved the litigation, and that was the defendants or appellants posting a picture of excrement on top of discovery that respondent had propounded. The rest of it were all random statements of where the respondent's plane was traveling in real time. Comments about him purchasing certain assets from Hunter Biden, the son of the president at the time, and posting his address and phone number online for no explicit reason. And none was really presented in the trial court below on this motion, and it resulted in harassment. He was subjected to many phone calls. People were apparently driving past certain properties that he owned, and other people were commenting about, let's exercise our Second Amendment rights and go get them. So that has nothing to do with the litigation, and also even the threat of litigation that was cited in the briefs. There was no threat of immediate litigation. There was no threat. There was no statement of controversy where this is why I'm going to sue you by a certain date if you don't take certain actions. It was an argument between two people where people become hyperbolic and state certain things. This argument was never raised in the trial court, and it involves statements of fact, determinations of fact that should have been weighed by the trial court. So it has been waived on appeal. Unless there are any other questions, I'll reserve my rights for further rebuttal, my time.
Well, I understand there's a cross appeal. It gets a little bit complicated as what's going to be argued at what point in time. I don't know if you just want to proceed now.
I would prefer to proceed now because the cross appeal is linked to the arguments that I made on the civil harassment claims.
Sure. They're all related. You know, these 5 claims that we're dealing with today, the doxing, civil harassment, the criminal impersonation, false light, IIED, they're all mixed up. It's very hard to separate them.
But the arguments with the doxing claim goes directly to the cases that I cited in regards to why you can pursue a civil action under a statute that is directed towards protecting certain people. And that is Angie M's v. Superior Court, Michael R. versus Jeffrey B. that said violation of a statute embodying a public policy is actionable even though no specific civil remedy is provided for in the statute. Penal Code 653.2 makes it a criminal act to dox somebody, post their personal information online. It is geared towards to protect people from that. Our allegations in this complaint, and we presented evidence supporting that, it occurred. The defendants posted my client's personal contact information, addresses, cell phone numbers, and as a result, he was harassed by the social media followers of the appellant. So it's the exact same argument under the same case law.
Okay.
So I'll reserve the rest of my time for further rebuttal. Thank you.
Well,
you want to present? I thought you were going to present your entire argument.
Yeah, right.
Excuse me.
You would prefer if you present your entire argument.
On Penal Code 653.2 for the cross appeal, that was my argument.
Yeah. Oh, all right.
Cross appellant's argument makes something very clear, that the cross appellant concedes that the appropriate remedy under a civil harassment claim, if you want expedited relief because someone is legitimately in danger, that is the correct procedure to follow. If someone is not in danger and they want to sue under civil harassment, that would imply there is no immediate harm. There is no incitement. There is no actual danger. And we're dealing ultimately with a free speech case, not just a harassment. And there's also something that is a very subtle shift here. The cross appellant is attempting to hold the defendant liable for third-party conduct. The plaintiff said that the defendants published information via text messages, telegram messages, social media, and other means, and that third parties then took action. But there is no allegation that there was an intent to cause third parties to harass Mr. Morris. Mr. Morris is an attorney. He's a licensed attorney in California. Mr. Morris knows that if he makes a statement that he is going to sue someone or have someone prosecuted, he's opening the door to someone being able to use the litigation privilege as a shield or to be able to defend themselves both in the public forum and in courts, to be able to say whatever they need to say in order to defend themselves, to gather information, to report about this, to talk to reporters about this. And I think what's gotten lost in this case is that ultimately this is about publication of truthful facts. Mr. Morris threatened Mr. Ziegler. Whether Mr. Morris was speaking directly to Mr. Ziegler or not, there's an allegation that Mr. Ziegler was impersonating another person on text message, but there's no evidence in the record of that. There's no phone number. There's no authentication of that claim. And it's the foundation of everything. We don't know who Mr. Morris was talking to. He doesn't know who he was talking to. He assumes it was Mr. Ziegler, and he threatens Mr. Ziegler with criminal prosecution, a criminal prosecution that never occurred. If Mr. Ziegler had been criminally prosecuted, he could have come to civil court and said, this man has been criminally prosecuted, and I have a right to damages as a result of this compelling evidence that there was criminal activity. But it never rose to that. It's just harassment by third parties who are not present in any proceeding before the courts. And Mr. Ziegler and Marco Polo can't control the way that third parties interpret their factual statements. The third parties may be absolutely outraged that an attorney, a licensed attorney in California, can abuse his position of power and threaten political enemies. They may be outraged that Mr. Morris has mansions and a plane that's flying all over and landing wherever it's landing, and that Mr. Ziegler and Marco Polo are reporting on that. It shows that Mr. Morris has the means, the money, to harass journalists, to harass anyone who publishes anything he doesn't like or that hurts his feelings. And nobody wants their feelings hurt. Nobody wants to feel embarrassed or humiliated or to have their family dragged through anything. But if you open any newspaper, you'll see that, because we have a First Amendment. We have free speech. I would ask that this court really hold the line here, because it may be very unpopular speech. We may not agree with it. We may think it's reprehensible, but it doesn't rise to the level of criminal conduct. It doesn't rise to the level of illegality. If it did, Mr. Morris would have gone and complied with the statute and submitted the form and protected himself, or law enforcement would have been involved and they would have prosecuted Mr. Ziegler. But that didn't happen here. I'd like to reserve my time if there is going to be a rebuttal to the cross appeal.
The people who harassed Mr. Morris may not be here, but they only knew how to harass him because of the posting of his cell phone number and addresses by the defendant. And we did allege, it's alleged in the complaint, that it was done with the intent to have these third parties harass Mr. Morris. It has also been alleged that they tracked his plane with the intent that they harass Mr. Morris. It is all about the defendant's actions in posting this information online. And the result of it was Mr. Morris was harassed. The intent of it was Mr. Morris was harassed. And that is why this lawsuit was brought. It was the procedure under 527.6. While you can do an expedited procedure, the damage was already done. The information about his home addresses and his location, pictures of his children, were all done. So he is subject to harassment. It is not a situation where neighbors are threatening each other. It's not a situation where, someone at work is causing problems. This is a situation where the action occurred and the damage was done. His information is out there to groups of people who are ideologically opposed to him because he has a relationship with the son of the president. That is, and the result of that is he was harassed and he was put under fear for his children. That is what we're here about. And while you have a First Amendment to free speech, you do not have the right to cause someone to be threatened, harassed, and have their children be put into danger. In regards to the litigation privilege, again, it was a text message that was people throwing around hyperbolic statements. He may have been an attorney, but under the law, and if you look at Edwards v. Sentex, that specifically says, even if you send a letter demanding you comply with a contractual obligation, that isn't sufficient to invoke the litigation privilege. So not everything an attorney says and makes statements of is sufficient to invoke the privilege. It has to be, what is the cause of action? It has to be more specific and more eminent. He never said, if you don't stop doing this, I will sue. The comments made were in angry responses and have no specificity of anything, of a cause of action, a claim, or an action that want to be taken. The litigation privilege does not apply. And none of Mr. Ziegler's other comments on Marco Polo's platform have anything to do with the litigation. It all has to do with, hey, I just sent this to Mr. Morris's address. Here it is. And here's his cell phone number. No justification why that was posted. The result of that was third parties, and it had to have been known that third parties may take those actions. So and again, going back to the cross appeal, it is, again, case law supports that if there's a statute that supports a public policy to protect people, they can bring civil actions, even though it's not specifically permitted. And that includes Civil Code 527.6, Penal Code 653.2, and the Criminal Impersonation Penal Code, I believe it's 659. And I'll reserve the rest of the right time for rebuttal.
I think that's probably it.
Good. That's your turn. Your closing, please.
The trial court also ruled in the same order, denying a preliminary injunction. And so there is this tension in this order where the trial court recognized that the conduct at issue did not rise to the level of a true threat. And that is the counterman standard. The Supreme Court has made it very clear that in order for harassment to constitute a true threat, it needs to rise to a certain level that it didn't rise to. There is a tension, therefore, in the order where the trial court did not believe that this conduct was imminent, dangerous, or anything enough to be enjoined, at least not preliminarily. And yet, these claims were allowed to proceed. Judge Epstein recognized this tension in his order, and there must be some way to reconcile this. Either there is a problem with the preliminary injunction, or there is a problem with the anti-SLAPP. We obviously believe it is a problem with the anti-SLAPP because with civil harassment, as offensive as the speech may be, as much as we may dislike it, we may find it distasteful, it is protected. It is not harassment. The trial court judge really grappled with whether or not this was an incitement case, and there was nothing in the record that showed that there was any intent to incite, that it had to be inferred because the publication of the address and the telephone numbers, and then the consequence of Mr. Morris receiving phone calls. What's missing is the causation. Mr. Morris is a public figure. He acknowledges that. His information, even his tail number, his addresses, his phone numbers, those are public record. The trial court found that that information was already available to the public. It's just that Mr. Ziegler and Marco Polo were compiling it. This simply doesn't rise to the level of the type of harassment that warrants encroaching on the First Amendment, which is what effectively Mr. Morris has asked the courts to do.
All right.
When we look at, thank you very much. Did you have a question, or were you simply?
No.
Okay, thank you. Then I'll submit. Thank you.
All right. Thank you very much.
All right, command is submitted then. Thank you. People versus Silverado Living, Senior Living.